You've heard the expression, you can't fight City Hall. It appears that the Municipality of Clarington City Hall is taking it to two of its residents. Jeff Kelso and Heide Kraus live south of Bowmanville, and they had to fight City Hall. And they won. Sort of. Today's guest at Exit 425.
In the main corridor of Exit 425.
Local politicians to connect with families.
What are some unique challenges?
Thanks very much, Steve, for having me.
Exit 425. It's where we live. Today, a couple that I've spoken with several times about their situation, which was chronicled recently by Moya Dillon of DurhamRegent.com. And I'll put the link to that article in the description of the audio podcast and on the screen in the comments on YouTube. Jeff Kelso and Heide Kraus were charged with a land use violation for something that had been more or less grandfathered 10 years ago. That charge was settled by a judge in March with an astonishing wrist slap by the judge directed at the municipality for how they have treated Jeff and Heide. Further, he thought the issue should be settled and over, but it's not. The town does not want to concede defeat without regard, the judge noted, for impending changes in legislation that will and has created the conditions that would allow their trailer storage to exist. Welcome to Exit 425. I'm Steve Ray, and today's guests are Jeff Kelso, and let's see if I can
one more time
pronounce her name wrong a third time. Heide Kraus.
Thanks for having us.
Hi, Steve. Thanks for having us.
Sorry, we just talked about pronouncing Heide's name properly, and I managed to change it 3 or 4 times. How and when did your conflict with Clarington begin, and did I capture the essence of it?
Basically, it did start the first time back in 2010 with an investigation into the land use of trailer storage, which we have been doing since 1996, and the previous owner from whom we purchased the land also was doing. And then we heard nothing. The problem went away. Nothing happened after 2010. And then suddenly bylaw showed up again at our door in 2020.
At the start of COVID.
At the start of COVID.
The most horrible time.
And interestingly, the only reason that we were aware that the original charge was dropped is that we did a freedom of information, and in literally 1,000 files of vomited information that we got from the clerk's office was a teeny weeny little piece of paper that said electronically file closed. And we've sort of been doing this dance now with Clarington since 2020.
So for way more than 10 years, the land was being used for trailer and RV storage.
We don't know when it started because it was a previous owner.
Sure.
But
so at least
30 years.
96, right? You said?
96.
And so, all this has been happening, and then you had the one issue and the file was closed, and you don't even know why it was closed, but it was closed.
Yes.
But you never had neighbors complaining about you or people pounding on your door and saying, you shouldn't be doing that, I'm going to report you, nothing like that?
That's one of the most upsetting. There are many things to be upset about with this case, but the bylaw department is supposed to be a complaint-driven process. In other words, bylaw officers are not supposed to be out cruising the community and looking for ways to be punitive with its citizens. They are supposed to, as you say, respond to complaints and concerns, and they can't be frivolous or vexatious. There are all kinds of restrictions about situations that they're prepared to look into. And that's the way bylaw is supposed to operate. And we'd said from the get-go that we couldn't believe that there'd be a complaint because we only essentially have one neighbor who owns 600 acres around our farm. And then, of course, then the 401 on the south side. So it was unconscionable and unimaginable that there'd be a neighbor that would be concerned. And of course, I spoke to anybody in the immediate area, and nobody had any concerns with the activity. And as it was bared out in the trial, there was no official complaint. They were unable, the prosecution, to produce an actual complaint. So they were here of their own volition, trying to flex their muscles. And that is a complete contradiction and contravention of the bylaw procedures and policies. And so that's just egregious behavior for the bylaw department to take with anybody in Clarington. And everybody should be very concerned that bylaw could operate in this manner, because they can show up at your door at any time and walk into your backyard and start an investigation. And that's very unsettling. And the judge proved that to be the case.
In fact, he made a reference to that, the idea of bylaw operating seemingly independently and out of the reach of counsel. Is that correct?
Yes, in the ruling that we've sent you, the decision that was made, I believe, what was the date? May 10th, 24, in Provincial Offences Court. The Justice of the Peace, McDonald, characterized bylaw as being offensive and unfair to the people of Clarington. MacGyver, the head of the bylaw department, was actively aggressive, biased, and prejudicial against the couple, seeing that and it goes on in great detail. But yes, he was very critical of the conduct of the bylaw department, and it was obviously with respect to our case.
And I will.
So that gets into my next question, just the idea that clearly you challenged the offense declared by the bylaw department, and we're talking about how that turned out. So maybe tell us what the decision of the judge was, and then we can get into some of the subtleties of the things that he shared.
Yeah, just if I can just go back and just point you to the corporate policy of the Municipality of Clarington, policy F14, which is the policy which exactly tells bylaw what they're allowed to do. And again, states that it has to be complaint driven, and they were not able in court to actually provide and show the Justice of the Peace that there had been a complaint. So I think that is relevant.
Relevant. It's very important.
Yeah, it's really relevant. So sorry, go ahead and ask your next question. Sorry.
No worries. So, okay, basically the judge decided in your favor.
Yes.
And shared these concerns about how bylaw operated. But what was the essence of the reason why he found in your favor? And perhaps how has the landscape of land use in Clarington and Durham changed over the course of your case, and where do we stand now?
So we did receive information from Durham Region that the Durham Region official plan was being reviewed, and they sent us to our mailbox, "Dear citizen, your land is being considered under the regional comprehensive review as having a change in status from agricultural to employment lands." So throughout the process, Durham Region sent us to our mailbox updates on this process, and we were made aware, a lot of them, that in May of 2023, the Durham Region Council approved the Durham Region official plan, which did change our land use from prime ag to employment lands. Subsequently, in September, on the 3rd of 2024, the province ratified that. And the province is very bullish on employment lands. Once the province has made something employment lands, there is no appeals process by which any level of government or any citizen group can appeal to any board to change that either to agriculture or to residential or to anything else. So as far as we understand it, it's locked in now as employment lands. Now, the truth of the matter is that Clarington still has to officially catch up their official plan. So when you look at, there's a web page for the Municipality of Clarington, and the Municipality of Clarington does talk about the fact that, yes, we have to come into compliance, but the wording is Clarington has to come into compliance with the region and with the province. So they know that they have a job to do, not that they get to pick and choose the route. So the part of it, obviously the corollary to all of that is, why then, after we have received this favorable ruling in May of 2024, would they turn around and appeal and waste all those tax dollars to do the same thing all over again?
Well, and the justice, according to the article that Moya Dillon wrote, the justice criticized staff for continuing with the charges when the municipality was actively studying the issue, and the region of Durham was also considering rezoning the property, which they have now done. And she indicated that before the end of the legal proceedings that had been completed. And so the judge was even puzzled why they were bothering to do that until all this was done, to make sure that your land either was or wasn't included and act accordingly. Is that right?
Yes, and the thing that is most egregious for us, because we are voters and we are taxpayers and we are civically engaged, okay? So we have tried through email, through trying to make a delegation to council, to somehow speak with our elected representatives, because they are the people who have to answer to us, okay? We were told, because the matter is being appealed and because the matter has gone before the courts, we will not talk to you. So there is a de facto steel or brick wall between us and our elected officials. And the irony of that is huge, because that is exactly the problem that Justice of the Peace McDonald identified in his ruling. So I think Jeff will read that for you, but this is not our words. We want to be really clear. These are the words of Justice McDonald. And this is page.
Yeah. So in the his ruling is quite extensive. It's 12 pages long. But on page 11, the last paragraph, and I'll quote, elected councils at two levels were in the middle of determining a change in bylaw 8463 that would allow business to be carried out under changes the regional government's official plan with Clarington Council following suit. The Kraus and Kelso property can now carry on the business. That's very important. Bylaw enforcement officers and senior staff had a responsibility and a duty to consider what future legislation elected officials were contemplating, as well as the direction elected officials wanted to take the community in moving forward as the community grows and develops. The laying of charges when issues regarding the future use of agriculturally zoned land are on the cusp of being changed and were changed is prejudicial to the family. Why bother to have elected officials at all if senior directors, managers, and enforcement officers who possess power and authority over citizens can act with impunity in a bureaucratic milieu where there is no accountability to anyone but themselves? Period.
So we don't elect these people. Okay? Our taxes pay for them, and our elected officials are supposed to keep, those people are supposed to be accountable to our elected officials. And so right now, we can't speak to anyone. No one at any level of government will have anything to do with us because it's before the courts. But ironically, the only reason it's before the courts is because the non-elected staff, as identified in the ruling by the Justice of the Peace, are the ones running this show.
To further illustrate that point of how staff is running this municipality, the whole idea of whether this decision was just, fair, or right never made it before council. Council members had requested that the bylaw department provide a report and give an update as to what was happening with our case. Unfortunately, MacGyver, on his own, decided to appeal the decision, never presenting a report to council. I don't believe they still have a report on what has happened in the court case. And he launched the appeal, citing something about some time restrictions, and didn't feel there was sufficient time for him to consult council, and he made this decision on his own. And so he has launched this appeal. Now, this appeal, as my wife has indicated, has just frozen the process for us. We have no access to government because everyone is fearful of bylaw and the lawyers.
No, everyone says that this is being appealed. This before the courts. That is the reason.
Yes, right.
That is before the courts.
So
until the courts rule, they're not going to say anything.
Yeah, they're fearful of any repercussions with Integrity Commissioner or any other agency that's sort of watchdog over how proceedings take place in the municipality. So consequently, we are completely cut off. But that really feels like that was the motive of the appeal. Not that it was justified or has any chance in being successful, is just to simply further tie up the property, further keep us away from the elected officials and isolate us. And of course, it's punitive because it continues to cost us money. And we have spent a pile of money.
Between $60,000 and $80,000 of our own money.
Yeah.
To protect the land that we have had since 1996.
Right.
I mean, it's also costing the municipality a lot of money. So
we have conducted a freedom of information about how much they spend on lawyers, and they would not give us a number. All that they said was, oh, we have the Durham Region lawyers on retainer for $40,000 a year. Well, I'm sorry. That is a non-answer, quite frankly.
And there's certainly other things that they could be doing, much better things they could be doing with their time
instead of our money working as taxpayers.
Working this case. But estimates, well, they're just estimates. We have no idea. But if we're spending 100, they're spending 2 or 3 for certain. Well, I have one lawyer. We have one lawyer. They have 3 or 4.
Yeah. Every time we go to court, there's a suite of lawyers from Clarington and Durham.
And outside counsel as well.
Yeah.
So you say and Durham. So is the Durham region supporting the Clarington?
They are retained. So Clarington, I guess, has hired the Durham regional lawyers to look after the case, because I don't know that Clarington has their own. You'd have to have someone else, but that's who they've retained.
Wow, it's pretty stunning. It's one of those things where you don't want your local councillors to be unduly influencing, bylaw enforcement, like making them back off when somebody's clearly doing something wrong. But that's where we've elected you, we pay you, and we pay the administrative team a fair amount of money. You should have the expertise to be able to find that line and get that sorted out, so that you can tell a counselor, look, that's beyond your reach, but there should be some expectation that our local elected officials are advocating for us. Certainly provincially and federally, we look to them on a regular basis to help ordinary citizens navigate the bureaucracy of necessary government.
Ironic, province. Yeah. So our MPP, as well as the Minister of Housing and Infrastructure, all of their offices, unfortunately, say, this is before the courts. We're sorry. We cannot intervene. So again, by launching this appeal, the people who are paid for by my taxes, but are answering to nobody, they are not elected. Nobody will give us any answers. Those people are actually running the entire show at this point, with no input from our elected people. And it's really, it's shocking, quite frankly.
Councillors in this case, there's clearly a reluctance to challenge bylaw. And as you pointed out, there are some very good reasons in situations where that would be most inappropriate. Don't feel that's the case here. But the Integrity Commissioner did a report a number of years ago regarding council's conduct with respect to bylaw, and provided some procedural guidance on how to deal with bylaw issues. And in that report, it allows for council as a whole to get together and discuss bylaw situations, so that they are not to be completely just isolated. And for whatever reason, they have chosen not to do that with our case, because, again, collectively, they certainly are in a position to delegate and discuss what's happening and how this is, spending taxpayers' money, and whether that is something that should be pursued or not. But again, they don't want to, or they haven't, or we have no answer as to why nothing's been done.
And ironically,
So
it has quite a robust.
Sorry, go ahead.
Clarington has quite a robust transparency policy, none of which they are following. No. Because council tells us to contact staff, we contact staff, they have no comment. So we are in an endless feedback loop of no answers, despite this robust transparency policy.
And freedom of information requests have been very helpful in procuring documents to help build our case at the outset of the process. However, you could characterize that now as a stone wall. Or the most recent freedom of information request, if you can believe it, was to find out information that conversations that were taking place between the region and the municipality with respect to Envision Durham. So I was concerned of a mountain of information. They had none. There was nothing to be provided.
And so the reason that that's important, Steve, as we mentioned, in 2020, this began with a visit from the bylaw officer, Officer Williams, and that was in the winter. October 14th, 2020, we had a pre-consultation meeting with representatives from planning, but they also had Ministry of Transportation staff, they had CLOCA staff. So there were inputs from many, many stakeholders about what we could do to bring our land use into compliance, because this was at the beginning of the process. And you have a room full of planners. Envision Durham started in 2019. Okay, this is a whole year later. This is 2020. So these people said, your land is ag. Nobody at Region of Durham is going to support a conversion or a change. This is going to cost you alone $40,000 to $50,000. I have these pre-consultation minutes in writing if anybody wants to see them. This is going to cost you as landowners $40,000 to $50,000. And the kicker is we cannot support this change in land use because we do not think it is appropriate.
Not appropriate.
Fast forward 4 years. Okay. And here we are. Our land use has changed. We are no longer prime ag in the Durham Region Official Plan. Envision Durham, which started 2019, has come to fruition. So our question is, wasn't it a single planner in Clarington in 2020 at the date of our pre-consultation meeting who might have known that this was coming? Like, I mean, obviously we have no proof. We tried freedom of information from both ends and we got nothing. But common sense dictates that it takes longer than 4 years to make that kind of a big decision, and that there's no way there are people in Clarington planning who didn't know in 2020 that this was coming. Does that make sense, my little rant?
Yep. Yeah.
Timeline, right?
It's all quite puzzling. The fact that you heard nothing for so long, that there was a case that was closed and there was no penalty for doing what you were doing, that the nothing, there was never ever a complaint, which I don't know, that's kind of like I'm sure there's an analogy we can come up with in a criminal court case where there was no evidence,
right.
There was no body, there was no weapon, something like that. And so how it carried on from there. And then on top of that, the judge was able to just put all kinds of stuff piled on in his decision. It's quite puzzling why this is even an issue. And it's like the cherry on the whole operation here is that the land use has been changed, and all evidence to you and everybody else seems to suggest that it's now appropriate for the land use that you have. Now, here's a question.
Yeah.
If perhaps there was a small property next to yours, now also considered to be employment lands, right? Based on Region of Durham and Province of Ontario. And they decided to start parking trailers on their property, would they be subject to the same kind of land use violation charge that you faced?
Well, actually, I have a good answer to that one. So that's a hypothetical which we couldn't possibly know. But given as the land designation has changed, you certainly wouldn't think so. I'm sure there would be some site plans that would need to be done, some bureaucracy work that would need to be done, and to allow for it. But we did a delegation before council early on, talking about the RV issue, because this is not just about Jeff and Heide. We did a very extensive report and found 50 sites within the municipality of Clarington where over 2,000 RVs are being stored. So this is not a problem between us and the municipality. This is a problem that pertains to tens of thousands of people in Clarington. We're not downtown Toronto. We're the 905. we're a community that has trailers, has boats, has RVs, ATVs, on and on and on. And there's just no provisions for it to be stored on your property in town. The bylaws are very clear.
Yeah, just a really quick thing. The province tells the municipality you must create
I was
a
gonna get there.
complete community, and you have to take care of your people, and that includes RV storage. In our pre-consultation meeting, the planner said, send them to Belleville. I'm going to send you.
That's another
a
really
form.
good one. But
I'm going to send you what they said that people should do.
clearly they're not planning for
They're
it.
not planning. They don't care.
And yet there has to be something done with these RVs. So there are many sites that have been allowed to operate and continue to operate, that have been investigated by bylaw and are still operating. So if you refer, as you were saying, a criminal case where there was a legal precedent that's been set, again, bylaw just falls on deaf ears. They don't care. They just simply are so laser focused on us. It makes absolutely no sense. And anybody who lives in Clarington knows multiple locations where trailers are being stored. Mm-hmm. And why they are coming so hard for us and spending such an exorbitant amount of money fight a losing case. They can't possibly win with all of the changes that have happened. They continue to spend taxpayers' dollars on an appeal. It makes absolutely no sense.
How does this end?
How does it end? Well, I would love to know. But I think
we're going to court. Yeah, we have no choice. They've dragged us. We keep spending money, which is maybe that's their goal. I don't know. Yeah, I'm not them.
Again, it's being punitive. So we'll stay the course. We're not going to back down. We feel the law's on our side. We feel completely justified in the actions that we're taking. We do feel that we've been harassed and
the judge says we have been harassed and bullied.
Yeah,
it is in the ruling.
So it's incumbent upon us really to see it through, to stay the course, and get perhaps a victory in appeal court as well. And then armed with a victory in appeal court and provincial offences court, we're in a very strong position. And we'll have lots of options moving forward and how we're going to deal with the municipality and what's taken place. But until that time, our focus now is to get through the appeal process and again, be victorious in appeals court. And we will do whatever is necessary and within our means to stay the course and keep the fight up, because they clearly would love us just to roll over and walk away and give up. And this is just so unrealistic for the average individual to take this fight on over a bylaw matter. But we're so committed now to getting a positive ruling in appeals court that's what we're going to do.
Well, the option is not tenable. The option is to tell all of our tenants to go find somewhere else to park their RVs. And it's not appropriate because the land use is the land use. And there's no reason to do that.
It's a pretty unusual situation, really, where you've gone through the timeline that you have, like we've talked about a couple times now. That nobody bothered you for a long time, and the land has eventually been changed, the zoning, into this employment lands. It's unlike if somebody had a trailer storage on agricultural land that won't be changed. I mean, that they might have a case there in order to change that land use, but it's not like yours will necessarily produce a precedent because so much has changed and been grandfathered. And it just seems to me, my layman sort of approach to things, that it's not really going to establish much of a precedent, even if they go to the wall with you as they appear to be doing.
You talked about if it was agricultural lands. That brings up a couple of interesting points. We'd also made a delegation before council and suggested that this RV issue be looked into further and perhaps some accommodations made to address the requirements for the municipality. As my wife pointed out, the province dictates that under the Greater Toronto Golden Horseshoe Plan that, we have to be a complete community. Clarington has to find a solution to this problem. It's incumbent upon them to take care of the services that are required for its citizens, not shipping us off to Belleville, They need to come up with a solution. So fortunately, Adrian Foster and council at that time determined to hire an outside consultant, which they did, DM Wells out of Peterborough, and they allocated $15,000, which is a drop in the bucket now, considering all the money that's been spent fighting us.
Right.
$15,000, like it was some huge sum of money, to hire a consulting firm to look into the problem. And they did so. It took several months, and they made a report and made suggestions to council. Council took that information and basically downloaded it or handed it off to staff, the agricultural committee in particular, to look at the recommendations and also the provincial policy statement that says that outdoor storage of recreational vehicles and boats and trailers is a permissible on-farm diversified use. And using that and the report, come up with some suggestions. There was talks about how it would be limited. Kelso's is perhaps too many trailers. 3 is perhaps not a sufficient number. Let's find some solutions. Well, that's died on the vine. We don't know what's happened with it. Council really needs to stay on top of staff in this matter and making sure that they come up with some solutions for RV storage and agricultural lands. So even if we didn't have this redesignation, we felt we had a very strong case to conduct and carry on our business in the current zoning, or per me, now it's in the past, our previous zoning. So we can't win with that logic and with good arguments on ag lands. And now we're armed with all of the support from the province and the region to do it in this current land designation. And they're still fighting us. So it doesn't seem to make any difference what the policies of the day are. They are determined to shut us down. And it's ridiculous, honestly. It's ridiculous. Sorry.
Well, there's so much to choose from here, but what has surprised you or shocked or amazed you about how this whole thing is playing out?
The lack of common sense and the willingness to waste taxpayers' money without any accountability to the taxpayer. And this is like one thing that I'm aware of. It's a tiny little thing in the global budget of the Municipality of Clarington, but it gives me pause to think, what else is going on? Like if this is how things are conducted, this is just me as a person talking. This is not me making an accusation. This is just the little hamster running in the wheel between my ears, and the hamster saying, like, what else is going on that we don't know about as taxpayers, as citizens?
Everybody that hears about the story, our clients, people that we've contacted for
Friends,
advice,
family,
they cannot get their head around it. It absolutely defies logic and sensibility.
Yep.
As
Common
Heide
sense.
says,
No common sense.
there is absolutely no common sense here.
And funnily enough, when I see this and how this is unfolding, I 100% understand how Rob Ford got elected in Toronto, which I never thought I would utter those words. But this is an extreme example of bloated bureaucracy working against the voters, against the taxpayers, against the province, against common sense, and against the current legislation. For what? I don't know for what. People will have to draw their own conclusions, but we've presented all the documents. We've presented the ruling. Names. Not ours. We didn't do it. The Justice of the Peace did it.
Yeah, and you've provided me the documents. I mean, I've got the Moya Dillon article in front of me. I've got the judgment from Justice McDonald in front of me, and everything that you said I mean, it's nice that it's in Moya Dillon's article, but it's all in the justice's decision, and I think that's even more stunning than what's happened. Is just the fact that this justice has stood out. There's apparently in a few decisions around different things in Clarington lately in the last couple of years, there's been some really stunning admonishments, I guess, by justices in those different cases, and yours is one of them. So it's amazing. I mean, it's one of those words that applies in a lot of situations, but I appreciate your observations about the things that that are standing out for you. I mean, you've gone through a lot, you've spent a lot of money. It would have been easy to pack it up and go to Belleville and receive those trailers from Clarington. But you haven't. You've stayed on the farm, and and went toe to toe with the town. So hopefully,
choice. Let's be really clear. We're Ukraine. Okay, we were invaded.
Yeah.
Okay, we're just sitting here doing our thing since 1996, happily, joyfully.
And then during COVID,
asked for nothing.
On lockdown with all our kids at home, trying to wonder how, nobody can go to work, how bills will get paid. We noticed somebody out walking the property, taking pictures, and it's by law looking for some reason to shut down a business at the break of a global pandemic.
And people have no passports. Kids are out of school. Okay, what can families do in a pandemic? They can go RVing. Yeah. And what's Clarington doing? Trying to shut down RV sites in the middle of COVID when everybody is stuck at home.
Talk about being blissfully unaware of the surroundings that you live in and the world that you're in. Just, you have an agenda, you're sticking to it, and the hell with the consequences or whatever else is relevant. They've got blinders on, and who knows why. We'll probably never know. Nor do we really care.
We just want it to end.
Yeah.
Like, we just want to carry on with our lives. We want it to end.
Of course. I appreciate you taking the time today to share this with me and to share your frustration. And, part of the challenge of being in Clarington is the local elected politicians have no media to speak to hold them to account. Thankfully, Moya Dillon is one of, I think, 4 reporters assigned to Durham Region, and she has a special interest in Clarington and does a lot of work here. And this is part of my mission with Exit 425 is to try to give people a voice and encourage people to be in touch with their politicians. And you've done that, and it hasn't helped much. So, that's one of the challenges, living in a media vacuum. So I really appreciate you taking the time to meet with me at Exit 425. And very quickly, what would you recommend for anyone who's in a similar predicament?
Leave Clarington. Get out. Go somewhere.
Go to Belleville.
Where business is welcome. Get out. Run. Put it in your rearview mirror. That's the message they're sending.
Yeah.
They're obstructionists.
Wow.
They are not facilitators. They're obstructionists. It's not good for.
Isn't that a disappointing thing?
Sure.
So,
for your time, Steve.
Yeah, and you know what? At the end of the day, we are not so full of ourselves as to think that the issue matters to everybody, right? It's RV storage, right?
How benign.
Like people when we get that they don't care. What you should care about is the lack of accountability, the lack of transparency, and the way your tax dollars are being spent without your municipal officials being consulted. That's what you should care about. Because if it's RV storage today, it's going to be the building of a multi-million-dollar something tomorrow, right? It's process. Everything in this world is process driven.
Obviously, we wouldn't have anticipated you having to go through this, so we can't really imagine what else could be put into the situation. So once again, thank you very much.
Thanks.
I appreciate you doing this, and I really appreciate you sticking to, the judgment, because that's where the truth is at this point. And hopefully, for your sake, this ends in your favor very quickly. I know it appears that the town is doing their very best to not make that happen. So
let us know if you have any more supporting documents for yourself to post, because I have a litany of them.
Yeah, so I'll put links to the article online, and I'll leave it to people to maybe reach out somehow.
Certainly.
And if they need some help or are interested, to talk to you about it and find out more information about the actual case. So thank you very much. Look forward to chatting with you about progress, hopefully in the very near future. And once again, hopefully something in your favor. Thank you.
Thanks.
Thank you.
Thank you for listening to this episode of Exit 425. Please like and subscribe on your favorite podcast platform and on YouTube. Our mission is to provide substantial information and education that goes where you want, because it's where we live. Exit 425 is a production of Studio 38 Audio, copyright 2024. My name is Steve Ray. If you have any questions or would like more information about Exit 425, join our Exit 425 Facebook group, like the Facebook page, check out Instagram, Medium, LinkedIn, X, and TikTok, or email me at exit425-401@gmail.com. Exit 425. It's where we live.